So James, you get to actually go home early today. So you know.
Mr. Chairman, I have 5 kids, right?
I know, right? You've got 5 kids, and I'm glad we got you out early for a change.
Thank you, sir.
There's someone waiting for you to please come home.
That's right. Mr. Chairman, members of the committee, my name is James Quintero. I'm a policy director at the Texas Public Policy Foundation. I want to thank you today for giving me the opportunity to offer a few thoughts on the ETJ reform interim charge, which I believe is central to property rights, the rule of law, and self-determination. In fact, I want to thank this committee for championing SB 2038 because I believe it is one of the most consequential pieces of legislation that passed last session. It not only enables individuals to now participate in the democratic process, or at least have some avenue to do so, it also mitigates real concerns about regulation without representation, and it forces cities to finally take into consideration ETJ residents' concerns. In the short time that I've seen it go into effect, I really have 3 observations to offer, and hopefully this is of some use to the committee. The first is that the law has been well received and widely used by the public. And the 3 cities where I want to highlight are Austin, Fort Worth, and San Antonio. There's some new information out that suggests in Austin's ETJ, as of March 14th, 2024, at least 300 released petitions were filed. And of course, some of those notable properties include the Austin Executive Airport, Tesla's Gigafactory, and the Austin Zoo. So people are very much using this new law here in Austin and Fort Worth. It looks like that within the first month after the law went into effect, the city of Fort Worth was petitioned with the release of 1,600 acres of ETJ land. The report also notes that since September 1st, 2023, that number has increased to around 2,000 acres. So widespread use in the Fort Worth area. And in San Antonio, in December 2023 alone, the city's planning commission recommended the approval of a resolution releasing approximately 555 acres. So lots of growth, development, and use in those 3 cities alone. Now, for as much as it has been appreciated, it's also been opposed by municipal officials in particular. Of course, we are all familiar with the litigation that's going on. More than a dozen different cities around the state are alleging that the new law is unconstitutional. I am not an attorney, so I won't speak to the constitutionality of the question, but it is worth noting that that matter is ongoing. What I do find a little troubling, though, as it relates to this litigation is the fact that there is active noncompliance despite the fact that this is a pending legal matter. There has been no decision rendered, to my knowledge, in any court that would effectively sideline the law, and yet
you have no trial restraining order.
Not to my knowledge, sir. And what you'll see here is a resolution passed in March 2024 by the City of College Station, which effectively says that we think SB 2038 is unconstitutional and therefore we're not going to follow the law. I think that is deeply troubling and something that needs to be accounted for in a future legislative session. I'll also note that in April 2024, another city, Aledo, also was denying petitions on the basis that that the motion was pending the motion was denied pending the outcome of litigation. So Aledo is basically telling property owners, we're not going to approve your petitions because there is some legal case somewhere and we'll figure it out later. Well, that's not what SB 2038 says. One of the reasons why I bring this up and how I want to try to tie this together is that the Texas Public Policy Foundation in March 2022 initiated legal action of its own as it relates to the extraterritorial jurisdiction concept. And the case we made in court was that the ETJ concept violated the Texas Constitution's guarantee of a Republican form of government. That's the central claim in this case here. We unfortunately lost at the district court level. We didn't find favor at the appellate court level. The matter is currently, under review at the Texas Supreme Court. In fact, last Friday, they asked for a further briefing from our legal team. One reason why I
How old is
mentioned,
this suit, so I know?
I'm sorry, sir,
How old is the suit?
March 2022.
Okay.
By the way, I am
Record is Bruce
informed,
Hosey.
I mentioned this for no particular purpose, but I am informed that Texas is unique in that the court will accept amicus briefs at any point during this review process. I mentioned that for no particular reason, but one reason why I
You
mentioned.
told me about College Station. I was just there this weekend. I might have been able to, I had a city council member in front of me. I just didn't know to ask the right question.
Well,
But I'll ask Longley in a second.
one reason, so we actually initiated the lawsuit against the city of College Station. So they are the defendant in this particular case. And why I bring all of this up is because in a July 2024 reply brief to the Texas Supreme Court, they state in defense of their position, they state Senate Bill 2038 went into effect on September 1st, 2023, providing a mechanism for opting out of a city's extraterritorial jurisdiction. So to the public, they are saying this law is a matter of legal controversy and we're not going to follow it. To the court, they're saying the public has SB 2038 and they can use that if they want, so the case is moot. So they're
Alito or College Station?
College Station.
Can I see the resolution?
Yes, sir.
Because it's okay, start, ask, could you pick that up? We'll keep you seated.
Sir.
Okay.
Senator, if I might add, one of our witnesses is from College Station and is a victim in this and has brought copies for everyone of that
Oh, I
resolution.
didn't mean to preempt anything, but, okay.
So I mentioned all of that to launch into the recommendations, which SB 2038, again, was one of the most consequential pieces of legislation from the last session. I hope, however, as we move into the next session, the body might consider a complete abolishment of the ETJ concept. As Scott already mentioned, now that involuntary annexation is no longer a thing, it really doesn't make sense to have the ETJ. I would also urge the body to consider perhaps empowering the Attorney General to enforce state law. I think this is one of many different instances in which cities and counties are seeking to go their own way, even though state law says differently. And I think there needs to be some sort of enforcement mechanism to hold these folks to account. So those are the two recommendations that we have for you, Chairman. I appreciate y'all's time.